Hello, everyone. I hope you're doing well. I am reporting from home. We are all homebound. We're all working remotely at AP Lawyers. And I just wanted to address a situation that, as family lawyers, we're getting so many questions about. I see the questions in the mom groups as well on Facebook, and we're getting lots of calls about it as well. And it's how to deal with parenting during COVID-19 and self isolation, staying at home, and all of that. So, what I think is really helpful is an endorsement I was reading today. It is a case that was just recently determined. It's Ribeiro and White in the Superior Court of Justice in Family Court in Hamilton. It's an endorsement that literally just came out March 24th, so just yesterday, guys. And as a result of COVID 19, which has caused the suspension of regular Superior Court of Justice operations, they're only taking urgent matters. And I'm sure if you have lawyers or if you're trying to get in the court system to determine what to do during this time, you know that it's practically impossible to get your matter heard, except it's extremely urgent. And what I really wanted to do is read out parts of this endorsement that I think are extremely helpful if you are dealing with the parenting arrangement during this time, a court order, separation agreement, consent, whatever it is that deals with the parenting of your children. So the main takeaways from this endorsement that I think were very helpful is that Justice Pazarat in Hamilton had said that in most situations, there should be a presumption that existing parenting arrangements and schedules should continue, subject to whatever modifications may be necessary to ensure that all COVID-19 precautions are adhered to, including strict social distancing. Okay, so basically, your parenting arrangement and schedule should continue as best as possible. If you have to make changes, it's completely understandable. This is the first time this has ever happened. The courts don't have the golden answer to this. So it's really up to you as parents and your lawyers as well, if you do have them, to make sure that they can come up with a solution just for the interim. Hopefully this doesn't last forever, but just something in the interim for the next several weeks, especially since the kids are off from school, okay? Another paragraph in this endorsement was that the judge was saying, and sadly, in some cases, a parent's lifestyle or behavior in the face of COVID 19, for example, failing to comply with social distancing or failing to take reasonable health precautions, may raise sufficient concerns about parental judgment that direct parent child contact will have to be reconsidered. There will be zero tolerance for any parent who recklessly exposes a child or members of the child's household to any COVID-19 risk. Okay, so that's something to really take into consideration. In this specific case, Justice Pazaratz had said, I have carefully reviewed the materials filed on this case, even in the absence of responding materials from the father. So this was a motion brought by the mother. The Justice Pazaratz has said, I've had the benefit of considering the emails he exchanged with the applicant's lawyer in relation to COVID-19 considerations. While the mother's concerns about COVID-19 are well founded, I am not satisfied that she has established a failure, inability, or refusal by the father to adhere to appropriate COVID-19 protocols in the future. So basically, even in light of that, even in light of the fact that the mother has raised concerns, and I'm sure they are very serious concerns about the father's care for the child during this time, the judge has really made it clear that it's still not enough, that he won't adhere to it. Now, if unfortunately the courts don't know. They don't know. There's a lot going on out there. Every family is unique. This isn't a one judgment for all cases. Towards the end of his judgment, Justice Pazaratz, and I really like that he said this, is he said, I would urge both parents in this case to renew efforts to address vitally important health and safety issues for their child. They also said that he also said that his denial of authorization to proceed with an urgent motion is without prejudice to the issue being returned to court if more serious and specific COVID-19 problems arise. So basically, it's more of a warning to the father as well. And if something more serious, or if he's going to continue his behavior, and if it really is putting the child at risk, because we're in a world where the situation is changing hour by hour, more cases are being discovered minute by minute, basically. And so the circumstances do change. The last paragraph of this endorsement actually says that none of us have ever experienced anything like this. We are all going to have to try a bit harder for the sake of our children. And I love that he ended like that. And I think that's a really big takeaway that I'm going to end with, that it's not a perfect situation. No one has the golden answers. Things are going to have to be changed. And there's really going to have to be an assessment based on safety precautions and what needs to happen. But all in all, you should try to follow as best as possible your existing parenting arrangement, and really try to make peace with that. Everybody wants the same thing. It's worldwide known that this is a very serious issue, and should be taken very seriously. It should not be taken advantage of where one parent says, well, just because of COVID-19 self-isolation, I can keep the child. That will not be tolerated, okay? So if you have any questions, feel free. We are working from home. We do offer video consultations, telephone consultations, anything that can avoid in person. So just give us a shout. We also offer a 20-minute question answer session as well in case you don't need the full consultation hour, and we're happy to help you with your concerns.